After viewing this video, if you connect with the idea that non-predators on the left and the right should unite against the predators on both sides, please go back and watch this video series from its beginning. Start with the introduction, Equalism 101, and move forward in order at your convenience. It's important that you become familiar with contract law before I talk about any specific failures of government programs. I've talked generally about contract law a lot in this series. Now I'll go into detail about why consent through contract law is so vital in a free, equalist society. I can make you a legal expert through 4 basic concepts of law that are mostly ignored in predonomics. No, I'm not a lawyer. Lawyers go to law school not necessarily to learn about the law, but to learn 2 things: court procedure and legal jargon. I'm no expert on either of those things. But I do know the law, all law, consumer law, criminal law, labor law, business law, tax law, international law, and the social contract itself is supposed to be based on one concept and one concept alone. That's the concept of contract law. Even the U.S. Constitution is nothing but a contract. I'll make you a legal expert by teaching you the 4 basic principles of contract law and their correct application. The 4 basic principles are good faith, consent, full disclosure, and mutual benefit. All laws are contracts, and when any of these principles are violated, then the law, the contract, is invalid. Contract law is simply the removal of advantage of one over another by mutual agreement. It equalizes human relationships. No valid contract enforces predation. Within every contract is an implied requirement of good faith. Good faith simply means you're dealing honestly with each other. It's not an option. Good faith does not have to be written into any contract. It's already automatically included. But honesty can only be demonstrated through mutual benefit. Also, consent can only be given through full disclosure, which is also demonstrated through mutual benefit. It doesn't mean all parties must benefit equally, but all parties must benefit to some degree. Mutual benefit is really the key to contract law. It's the only way to prove good faith and consent through full disclosure. No one is going to voluntarily sign anything that clearly says, you get everything and I get nothing. In his second treatise of government, John Locke writes, no rational creature can be supposed to change his condition with an intention to be worse. Your signature on a piece of paper is not an indication of consent. Your signature and anything you sign, in fact, means nothing in contract law. There's all kinds of ways to get people to sign anything. There's trickery, fraud, coercion, and force, which can all result in your signature and all violate any contract. And there's simple forgery, which also demonstrates a signature doesn't indicate consent. Also, consent cannot be given without full disclosure. Fine print violates full disclosure because its use is a clear indication of an attempt to hide something. Furthermore, needing to pay an attorney to understand any contract also violates full disclosure. All contracts must be written using plain, everyday language, not legal jargon. Legal jargon exists for two reasons. First, it creates a separation from the rest of society by creating a false authority and unnecessary dependence on the legal industry. Secondly, jargon exists to confuse and mislead. These violate the very concept of contract law. When laws and contracts are so confusing, you need to hire an expert to interpret them. It serves two purposes. First, it makes you pay for the protection of your rights. This discriminates against the common, who can't usually afford the extortion fees of the expert to have their rights protected. Secondly, it allows the elite to interpret laws and contracts in any way that benefits them. So for any contract to be valid, it must be agreed upon through good faith. It must demonstrate consent through full disclosure. And the only way to prove good faith and consent through full disclosure is with mutual benefit. Remember, nobody is going to voluntarily sign anything that clearly says, you get everything and I get nothing. Or, you're guaranteed betterment, but I risk becoming worse off. Furthermore, since all laws are social contracts and are intended for the social good, full disclosure also applies to the public's right to know. All social contracts are public declarations and must be available for public scrutiny. And there's no such thing as a binding secret contract, or any binding contract that contains within it demands for secrecy. Under Predonomics, the violation of contract law is so vital to elitist profits and the functioning of business and government, its violations remain mostly civil matters rather than criminal ones. This protects the elite from criminal prosecution when they violate contracts and civil laws, although contract and civil violations are clearly acts of corruption, fraud, and theft. Equalism will deal with contract violations as the crimes they actually are. Equalism considers consent to be so fundamental to human rights, you can't even consent to have your right to consent removed or violated. Your right to consent is revocable only upon your violation of someone else's right to consent. Since these four principles of contract law are so fundamental to human rights, why aren't they taught in schools? They need to be taught from kindergarten through college. Contract law is one of the foundations of equalism. So keeping in mind these four fundamental requirements of contract law, in the next video in this series, titled Equalism 107, we'll examine how the student loan scam violates contract law. Thanks.